Okay, if you own a home in a community with an HOA or a condo association, you know the feeling. You get that official looking envelope in the mail and you kind of hold your breath, right? Usually it's just the dues you're expecting. But what happens when you see a charge that just feels off? Well, we're going to dive into the story of one homeowner's fight over a single, very confusing line item on his bill.
So put yourself in this situation. You're buying a new condo, you're excited, everything's moving along, and then you look at the closing statement. And there it is, a $660 transfer fee. But wait a minute. You happen to know that the state law says the absolute most they can charge for this kind of thing is $400. So is your new association just blatantly breaking the law? Or is there something else going on here?
Yeah, that exact scenario is what we're breaking down today. It all kicked off when a new homeowner got a bill with a fee that just didn't seem to add up. This was the number that started the whole thing, $660. That's what homeowner Brian Sopatyk was charged, listed as a transfer fee, right there on the paperwork when he bought his new condominium. Now here's the kicker. Arizona state law is crystal clear on this. The statute says the maximum, the absolute total an association can charge for all of its resale disclosure services combined is $400. So you look at these two numbers, and on paper, this looks like a slam dunk case of overcharging, right? And that's exactly what Mr. Sopatyk thought. He believed the law was totally on his side, so he took action. He went and filed a formal petition against the Lakeshore Village Condominium Association, claiming they straight up violated the statute. And this, my friends, is where the story takes a really interesting turn. The association didn't deny charging the $660. Nope. Instead, their entire defense was built around a really simple but powerful argument. They just called it the wrong thing. You know, Mr. Sopatyk's case seemed pretty airtight. He had the documents to back it up. He had a disclosure form from the association itself that said $660 transfer fee. He had the official settlement statement from the sale, which also called it a transfer fee. And, of course, he had the law. It really looked like an open and shut case. But the condo association came back with something pretty surprising. They basically said, whoops, our bad. It was all just a big misunderstanding, a simple clerical error. They argued that the money itself was perfectly legal for them to collect. They just slapped the wrong label on it. So, to understand this, you gotta know the difference between two very different types of fees. On one hand, you have a resale disclosure fee or a transfer fee. That's for the paperwork and admin costs when a home is sold, and that's the one capped by law at $400. But then there's something totally different called a working capital fee. This is basically a buy-in from a new owner to help build up the association's rainy day or reserve fund. And here's the key, that fee is not capped by the same law. The association's entire case was that the $660 was the second fee, not the first one. Okay, so to get to the bottom of this, the judge basically had to become a detective and follow the paper trail. Was this a deliberate, illegal overcharge, or was it really just an honest-to-goodness mistake? And this quote from the association's own board meeting minutes really gets to the heart of it. After Mr. Sopatyk raised the issue, they actually documented it. They admitted, right there in the minutes, that the label was wrong, but insisted the intent all along was to collect a perfectly legal working capital contribution. The property manager, Amy Tellness, even testified about how this whole mix-up happened. She explained that their governing documents, the CC&Rs, absolutely allowed them to charge a working capital fee, but when she took over the job, the previous manager had told her to call it a transfer fee, and the wrong name just stuck. And here's the most crucial part. She provided proof that every single time they collected the $660, the money went directly into the reserve fund, the working capital fund, and not into their day-to-day operating account. And here is the final little piece of the puzzle that really backed up the association's story. It turns out that on these same closing documents, there was another totally separate charge, a $30 statement fee paid by the seller. The association argued that this was their legal capped fee for the paperwork. The $660, that was for something else entirely. So with all the evidence on the table from both sides, it all came down to the administrative law judge to make the call. How did this thing finally shake out? Now, in a civil case like this, the person bringing the complaint, in this case Mr. Sopatyk, has what's called the burden of proof. He had to prove his case by a preponderance of the evidence. It sounds complicated, but it's not like in a criminal trial. It just means his side of the story had to be more convincing, even just slightly more convincing than the association side. And in the end, the judge decided he hadn't met that standard. The judge concluded that, yeah, the fee was definitely mislabeled on the forms, but the weight of the evidence, the board minutes, the manager's testimony, where the money actually went, and that separate $30 fee, all pointed to the fact that the $660 was, in substance, a legal working capital fee. So the judge's final recommendation was to dismiss the petition. That was accepted and finalized, becoming the official decision. For Mr. Sopatyk and his claim, the case was closed. So what's the big deal? What does this case actually mean for you? Well, it offers some incredibly important lessons for anyone who lives in or is even thinking about buying a home in a community with an HOA. Probably the biggest takeaway from this whole thing is this. In the eyes of the law, what a fee is matters a whole lot more than what it's called. A simple clerical error on a form didn't end up invalidating a fee that was, in its substance and purpose, perfectly legal to collect. So how do you avoid this kind of mess yourself? First, and this is a big one, before you buy, actually read the association's CC&Rs. They will spell out what fees, like working capital contributions, they can legally charge. Second, go over your closing documents with a fine-tooth comb. Seriously, ask your real estate agent or your attorney about every single line item until you understand it. And finally, if a fee looks weird or feels too high, do what Mr. Sopatyk did. Ask the association directly, what is this for? And can you please show me where in our governing documents it says you can charge it? This whole case is just a powerful reminder to always look beyond the labels on the paperwork and really understand the substance of what you're paying for. It really leaves us with one last question to think about. When you get that next bill from your own association, will you know the difference?